Thank you. I appreciate it. So I am Sam MacRoberts. I run Kansas Justice Institute, and just a little bit more about KJI. We are a nonprofit pro bono, meaning free law firm. And what we do is we file cases and push back against what we think is government overreach. And so we do that in a lot of different areas. We have filed cases challenging the government's ability to conduct warrantless inspections. In a case where a family was the Department of Agriculture was conducting surprise warrantless searches of this family for nearly 20 years. And if the family wasn't there for the surprise warrantless search within 30 minutes, the person could lose his license or his livelihood. So we ended up filing a federal lawsuit in the District of Kansas, and the judge dismissed our case, but we continued on and we took it up to the 10th Circuit Court of Appeals. They reinstated our case, and then eventually we had a trial in front of the very judge who had originally dismissed us, and she ruled in our favor. So now our client's home cannot be inspected without a search warrant. So that's the type of cases we do. But we've done everything from that type of case. We've defended asset forfeiture victims, so people where the government will come in, law enforcement, and seize a person's car and try to forfeit it, meaning take it away from them. And so we will represent those individuals. And in fact, the two forfeiture cases that we have done, we've gotten the cars back to them. And of course, we've done free speech cases, which we're going to talk a little bit about today. So we can have Q&A at the end, or because we're talking about free speech, it seems to make sense to me that you guys can ask questions as we go along. If you have thoughts or opinions, you should just be free to share them. I think it makes it more fun. It's more interesting. I'm also not a professor. I'm not a lecturer. So for me, this is a little bit more difficult. What I'm used to is being a litigator, because that's what I am. And so then I come in and I make arguments. I don't necessarily lecture. If I were to lecture a judge, that would probably be pretty bad. So all that's to say, just ask questions. It'll be a lot more fun. And I think maybe we'll learn more. And I actually get a lot out of Q&As, because I don't think about things, perhaps because I've been trained as a lawyer, so I don't think about things the way some people do. So I actually learn a lot at these. So let's go that route, if it's all right with you all. And I know you have your questions, so you can ask them at any point. So today we're going to talk about free speech and the First Amendment, and we're going to talk about everything from sending pamphlets in the mail to saluting the flag to the Pledge of Allegiance. We're going to talk about Nazis parading in Illinois, and we're going to talk about the burning of flags. We're going to talk about raw milk. You may think, how does raw milk fit into this? And then you're going to ask it again, because we're going to be talking about hamburgers that look like UFOs shooting ketchup and mustard. And so what we're really going to do is we're going to talk about all these things, and we're going to go through almost 300 years of history and tradition, and we're going to go pretty fast. I'm also a fast speaker. So that's why it's important to ask questions as we do this. And by the way, I've never done a PowerPoint before, so bear with me if anything goes haywire. All right, so today we are talking about the First Amendment. I think what's really interesting is that the First Amendment is only 45 words long, and it protects 5 freedoms. And I think a lot of people, when you're discussing the First Amendment, they don't realize that it's something more than free speech. And it's Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or the press, or the right of the people to peaceably assemble and to petition the government for a redress of grievances. And by the way, all of these images, I have made sure that they're in public domain or we have paid for them. So I think what's really interesting is how, as a modern society, we view free speech versus perhaps how we viewed it at the time of the founding. And I am approaching 50 years old, and so for me, it's very interesting how perhaps my generation thinks about things versus my mom's generation. She's in her 80s. And then my kids, who are ranging from 2, she doesn't have a lot of opinions on free speech yet, up to my son who's 11, and my wife, who is 7 years younger than I am. And so to me, the more that I have been thinking about these things, there seems to be perhaps a generational divide about what free speech means, what should it protect, and this is where I think it'd be really interesting to hear everyone's viewpoints here. So here are the modern views. This was a study that was conducted by FIRE, which is an organization that's dedicated to free speech and expression. Gen Z is 10 times more accepting of violence against speakers than boomers. Gen Z is 25 times more accepting of violence than the silent generation. And they say 43% think violence against speakers is acceptable. In a different study at the Florida State University, 20% of young adults believe that people can employ violence to prevent speech. And 37% of people agree that speech should sometimes be restricted when it conflicts with inclusivity. And I think that really goes to the heart of today's discussion. When we talk about free speech, what do we mean? Do we actually think it's essential to liberty? Do we think it's essential to freedom? I have a pretty strong viewpoint on this, but I would guess not everyone agrees with me. And I would guess, based upon these stats, other generations don't agree with me. And so it's really important, I think, today to have that conversation. You know, there are recent examples or trends of these types of things happening. So at UCLA, one of the head lawyers from DHS went to go give a speech at UCLA, and the event was disrupted. Students at UCLA would not let the attorney essentially give his speech because they did not agree with what he was saying. And if the media reports are correct, what he was talking about, or what he was planning on talking about, was whether or not you could use administrative warrants or no warrants to conduct what amounts to ICE raids. And so rather than allowing the DHS lawyer to talk about it, this speech was disrupted. And to me, that presents a very big problem, because if you oppose what the DHS is doing, and I think there are a lot of people who do, wouldn't you want to hear what they have to say? And then perhaps through your questions, ask why they support that, or if there's any basis in law for what DHS is doing, rather than shutting down the event. Another disturbing case, disturbing from my perspective, but of course everyone's allowed to push back here today. At Stanford in 2023, a Fifth Circuit judge, Duncan, wanted to give a speech to the Federalist Society. And he was prevented from doing it. He was shouted at. A lot of students were prevented from going in to hear Judge Duncan give his speech. And after that, there were more studies conducted, more percentages about whether or not that was acceptable. And 60% of Stanford students said that someone who has stated that same-sex marriage is unconstitutional should not be allowed to give a speech at Stanford. And 3/4 of Stanford students said that shouting down a speaker was acceptable. And 3/5 of Stanford students said that blocking other students from attending the campus speech was appropriate. And more than 1/3 of students said that using physical violence to stop a campus speech is also appropriate. Just yesterday, I was told that there was something happening at Kansas State University where I believe a student was sitting in a common area and was using the N-word and had the N-word sign out there. And there were a lot of students who said that that person should not be permitted to speak in that way on campus. And that raises really interesting questions that we're going to discuss later. And so I think that, and I believe the NAACP was calling for the student to be removed from campus. And the Black Student Union was also suggesting that that person should be removed from campus. And that goes to the heart of the First Amendment and the cases that we're going to be talking about today and what that means. And I think it really does raise a very interesting and fascinating questions. Is allowing that person, let's assume that that is allowable on campus, does that make us a better society? For some of us, we just accept that it does make us a better society. And for some of us, we think it should not. It doesn't make us a better society. And so I think it's an interesting and open question. Is it worth it for speech to allow somebody to do that at a school campus? That's what I hope we talk about today, because I bet we all don't agree on that. So what were the views at the time of the founding of our country? Wouldn't be a presentation without Cato's letters. That was kind of a joke. Has anyone heard of Cato's letters by any chance? All right, we've got a couple. So Cato's letters were written in the early 1700s by John Trenchard and Thomas Gordon. They were instrumental to the founders. And the Cato's letters really informed the views of our founders. And there's a particular letter written in 1720, Cato's letter number 15. Here it is. I've actually uncovered it. You can find all this stuff on the Internet Archive. It's amazing. On Cato's letter number 15, they wrote that freedom of speech is the great bulwark of liberty. And without freedom of thought, there can be no such thing as wisdom, and no such thing as public liberty without freedom of speech, which is the right of every man. And the sacred privilege is so essential to free government that the security of property and the freedom of speech always go together. And freedom of speech is of such infinite importance to the preservation of liberty that everyone who loves liberty ought to encourage freedom of speech. I know. Reading old documents is so frustrating because in my head I actually read that as freedom of speech, and it's horrible. But I think the modern views clearly don't square with what Cato's letters, what Cato, John, and Thomas were writing about in the 1700s. Okay, one of my favorite pictures of all time, which represents the Alien and Sedition Act of 1798. So the Sedition Act of 1798 prohibited publishing, quote, any false, scandalous, and malicious writing or writings against the government of the United States or either House of Congress or the President with intent to defame or to bring them into contempt or disrepute. And President Adams' administration used the Sedition Act to prosecute members of Thomas Jefferson's party. So here we are. This is directly calling into question First Amendment and free speech principles. So the state of Virginia issued a resolution saying that the Sedition Acts were unconstitutional, which is pretty interesting. Like in modern times, have we heard of a state issuing a resolution that something that Congress has done is unconstitutional? I couldn't think of an example quickly off the top of my head. But it's pretty neat that that's what they did. And of course, that doesn't mean that it is unconstitutional, but that was the opinion of the state of Virginia. So then here comes James Madison, which Renee saw when I was flipping through very, very quickly. So he published a report in response to the Virginia Resolution, essentially defending the Virginia Resolution. And he wrote, as you can see, that speech that creates a contempt or disrepute or hatred among the people can only be determined by a free examination thereof and a free communication among the people thereon. And what I take that to mean is the response to speech you don't like is to examine it, to actually have more speech, not less speech. And so when we're talking about speech at the time of the founding, we're talking about very similar things to today. Politicians were concerned that they're being made fun of, that they're being defamed. We're hearing the same things during this administration and perhaps other administrations. And so these things are coming full circle. But what other instances of speech and expression were allowed or permissible at the time of the founding? Oops. Liberty poles. I had forgotten about this until I was doing this. So what is a liberty pole? It's actually a pretty revolutionary, a pretty aggressive, caustic way of thumbing your nose at the government. You're taking a pole with flags on it, with an orange stocking cap almost, and you're putting it up in the town square for everybody to see, that is basically thumbing your nose at the government. And I had totally forgotten about this. And then here we are. Look at everybody hoisting the liberty pole. And what a revolutionary act. I mean, could you imagine what would happen, let's say, in the city of Ottawa, if a bunch of people put up a pole that was viewed as perhaps threatening to the city government? Or if you did it in Topeka against the state government, or in DC. But here, this was happening, and it was totally okay. And as a side note, what would a zoning board say about a liberty pole these days? And the burning of effigies, completely permissible at the time of the founding. I mean, I can't think of something that is, in modern times, such different, like you are actually building a representation of a person and hanging them from a tree, and that's a lot of times being lit on fire. And so the burning of effigies were happening, and back during the time of the founding, a lot of times it was the tax man. So they were obviously not enjoying the Stamp Act and everything else, and so they put up effigies. As I was trying to find the best kind of representation, almost every single one dealt with the tax man. So what would happen in modern times if somebody was putting up effigies of a tax collector, like the county tax collector, and you're setting the tax collector symbolically on fire? What would happen? What would the response be? So part of the lecture here is to talk about First Amendment cases. Okay, we're not just going to talk about Cato's papers. And it was very difficult to kind of pick what I thought were perhaps the most important cases or the most relevant cases. And so there are so many cases out there. If you have any that you want to talk about, bring them up. We'll see what we can do, or at least have a discussion about it. But so I chose these because I think they're important for different reasons. If you disagree, that's A-okay. And you should say it. Okay. Has anyone heard of this case? All right. By show of hands, you've heard of it?
Yes, but I can't fully recall.
That's okay. That's good. Are you a lawyer?
I am studying.
Oh, cool. Are you in law school?
I'm just approaching.
Oh, nice.
I'm doing my BA in pre-law.
All right. Well, this is exciting. So I may be calling on you a lot. I'm just kidding.
My brain is fried.
Trust me, I understand that feeling. Okay. How many of you think that it should be against the law to be able to send things in the mail, urging people to resist the draft? Okay. Is that a crime, or are you allowed to do it? So if you think it's appropriate to criminalize that, go ahead and raise your hand. Okay, so nobody here thinks that should be against the law. So everybody here agrees then that the First Amendment protects your right to send these mailers out, right? I got bad news for you all. Okay, bad news. All right, in 1919, that was what this case was about. And Charles Schenck was mailing leaflets through the mail urging people to resist the draft. And he was saying that the draft amounted to slavery. And so he was charged with the crime of, I see Jalen up there behind the camera agreeing with that. All right, now, he was charged with violating the Espionage Act, and he was convicted. And it went up on appeal, and the conviction was upheld. And Justice Holmes wrote this opinion, and he said, "We admit that in many places and in ordinary times, the defendants in saying all that was said in the circular would have been within their constitutional rights. But the character of every act depends upon the circumstances which it is done." He went on to say, when a nation is at war, many things that might be said in time of peace are such a hindrance that its effect and that their utterance will not be endured so long as men fight, and that no court could regard them as protected by any constitutional right. All right. Now, by show of hands, how many of you have heard you can't shout fire in a crowded theater? Is everyone's raising their hands? Not everyone. That wasn't actually the quote. It's crazy. That was not the quote, but that is how everybody remembers the quote. What he said was, and it's still wrong, but what I'm going to tell you what the real quote is, so you can correct people and be very pedantic about it. The most stringent protection of free speech would not protect a man in falsely shouting in a theater and causing a panic. There was never any crowded theater part. Everybody says it. That's not part of it. And the falsely shouting is also really important. And there are actually cases where courts are saying you can't shout fire in a crowded theater. Or at least you can't shout fire in a theater.
It's just an example.
It is an example. And here's what I think is so fascinating is it's a terrible example from my perspective. It's a terrible example for a lot of different reasons. So let's say, and we'll use his example, falsely shouting fire. What if you thought there was a fire? You thought there was a fire, but you're falsely shouting fire. Does the First Amendment protect that? What if during the theater presentation the actors are shouting fire? That's part of it. What if your intent was not to cause a panic, but to actually help people? So there are a lot of reasons why this analogy is wrong, in my opinion. But a lot of people use it in circumstances to justify restricting speech. And I think what also makes this a terrible analogy is that if there actually was a fire, or the circumstances of that incident are far different than sending out mailers that people have the time to read, that have the time to understand it, and can respond to the speech that they don't like. Whereas if you have a fire, let's say somebody pulls a fire alarm, you don't really have time to say, oh, let's hold on, let's debate whether or not this is accurate or not. But you do when it comes to mailers and circulars and speech. And I don't think that there was any evidence that the mailers were actually causing people to avoid the draft. And the whole point was, I think, that national security dictates that we can restrict this speech. That raises, I think, a very interesting and modern question. During COVID, when the Biden administration was restricting speech for false misinformation, when they were throttling Twitter accounts, would that have been proper? Would that have been appropriate under this analysis? I'll leave that for you to decide. Now, I will say that Schenck was effectively overturned in 1969 in Brandenburg v. Ohio. But the next time you hear that shouting fire analogy, I want you guys to push back. Okay. By show of hands, can a school require students to salute the flag and recite the Pledge of Allegiance? I know I said the Pledge of Allegiance every day in elementary school. All right. By show of hands, who thinks the school can require a student to do that? All right.
I do.
You do? Okay.
Coming from old school.
All right. All right. Now I'm going to change it a little bit. Who thinks the school should be allowed to require students to pledge allegiance or salute the flag? I don't think anybody really salutes. Maybe they do. All right. Russ thinks the school should be. All right. You don't.
I think kids should, but I don't think the school should require it.
Okay. All right. So your viewpoint is students should be doing the Pledge of Allegiance, but they should not be required.
They should not be required.
Okay. All right.
I think it should be more of a cultural encouragement and not so much of a law or rule to do so.
Okay.
So they should be able to opt out.
Okay. Opt out.
Freely opt out.
All right. Renee, what?
As a citizen,
Mhm.
you do pledge an oath of allegiance to the country, and that does mean respect our flag and the Pledge of Allegiance, so I do think everyone should, in the United States of America, pledge the allegiance to the flag.
Okay.
But some people have religious reasons why they feel like they don't want to pledge the flags and stuff like that. They actually do.
So Renee, do you think, and I hate to put you on the spot, but do you think?
I'm from old school.
I know, and this is perfect. This is perfect. So let me make sure I understand your position, that a school should be permitted or should be allowed to require students to do it.
Yes.
And if a student doesn't do it, some sort of consequence, like, I don't know, no recess or...
It is a public school. It's not really a private business.
Mhm.
So there's a difference in
True.
a way. It's private business. You have to do what the private business tells you to do, or you're out. With schools, I don't know where that would go if someone didn't. But I think we have it today. I mean, not so much in my area where I live, because I do teach the Constitution, and so all the kids know how to do the Pledge of Allegiance, because we do that when I teach them.
Mhm.
But I do think there are a lot of states that don't require, state schools that don't require, to do the Pledge of Allegiance, which is sad. It's sad. I mean, I just feel that every child is a citizen, should be a citizen that's here in the United States. That's the way I believe. And I just feel that that is one of our wonderful things about our country is the men and women that fight for our country. And the flag represents that, our freedoms. And I just can't, the burning of the flag's horrible. I mean, I could go on and on and on because I'm just very passionate in my country and I'm very patriotic.
Yeah.
So,
All right.
I'm sorry.
No. There's nothing to be sorry about.
Apologize.
Yeah, no.
I'm not sorry.
I know what you mean. Haley?
I think to your point, I think there are always exceptions, but I don't think you should make the exceptions the standard. And also schools are responsible for instituting certain characteristics, traits, and education into the children when they become of age. If you're 18, whatever, high school, whatever. You can kind of start to navigate your autonomy, but there are reasons why kids aren't allowed to drink and drive and do all these things at that age because they haven't fully developed those things. So I think if you set that standard as a youth, as an adult, if you choose not to, that's fine. And even if you have parents who are adults advocating for you and talking to the school and you go through a process to make an exception, that's one thing. But setting that as a standard, I think is important to implement that into citizenship.
Yeah, I think I have a little skewed view on all of it because I homeschool my kids, and when they were little, they were required. We would in the morning to say the Pledge of Allegiance
Right.
and all of that. They were. So just know that. And I'm also a naturalized citizen. So I chose this country, and I love this country. And that's one of the reasons why I'm going into law, because that's my way of being able to contribute back to this country. So I do understand that, but at the same time, when I look at it from a perspective of being a homeschooling parent, what I realize and understand is that you have to start that in the homes. You can take your kids to school all you want, but what are the parents instilling in those kids? When they go to school, they can go by route. And teachers can try their best to try to get those kids to love this country, honor this country, but it's what is coming in from their parents. Are their parents honoring this country? Are their parents respecting this country? Because they would naturally want to. They wouldn't want to opt out. They wouldn't want to. So it's just, I see it on a level of, we're trying to get schools to do something that I feel like is not truly the school's job to do. Where it becomes to parental autonomy, parents need to step in and take hold of putting those things in their kids, and the school is a support system. It's not the.
It is, I agree.
All right, Sam, I'm going to jump in and goes back to free speech, and
All right.
We'll try to keep more to questions
All right.
for the most part.
Yeah.
We can get into more discussion later, but
Nope,
let's continue on.
Yeah, so what is, I think, most important about this case is whether or not the school can require it. And what was happening was that they were required to salute the flag and recite the Pledge of Allegiance. And here's what I thought was really interesting about the case, was that students who did not recite the Pledge of Allegiance or salute were threatened with reform schools that were used for criminally active juveniles. So if you didn't do it, you were threatened to be sent to those schools. And parents were threatened for prosecutions for causing juvenile delinquency. And I think it was a great discussion that we just had, because the people who sued West Virginia over this were Jehovah's Witnesses. And so they did not believe in reciting the Pledge of Allegiance or saluting the flag. But the case was not decided on religious grounds, it was decided on free speech grounds. And I think that this decision, it was 6-3, okay, so it was not unanimous. There were dissenting viewpoints on this case. But what I love about this case, a lot of different, just as this discussion showed, there are a lot of people who like the Pledge of Allegiance, but then it gets really strange when we're talking about, do you require it? Like, I love the Pledge of Allegiance. I loved saying it as a kid. I was a Boy Scout. I'm an Eagle Scout. So, like, that stuff is really important to me. At the same time, I agree with the Supreme Court that you can't force somebody to do that. And here's what the Supreme Court said, who said it far better than I ever could. The freedom to differ is not limited to things that do not matter much. There would be a mere shadow of freedom. The test of its substance is the right to differ as to the things that touch the heart of the existing order. And here's my favorite quote, I think, of any First Amendment case coming up. If there's any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. If there are any circumstances which permit an exception, they do not now occur to us. We think the action of the local authorities in compelling the flag salute and pledge transcends constitutional limitations on their power and invades the sphere of intellect and spirit, which is the purpose of the First Amendment to our Constitution, to reserve from all official control. This case was in 1943. I think about that, like what was going on in 1943 that the United States, the World War II, that the United States Supreme Court is now saying at that time, you cannot force kids to do this. And I love that I love the fixed star in the constitutional constellation. It's such a powerful, in my mind, turn of phrase, and it's been used since then.
Which justice used that?
I don't recall who wrote the opinion. You got me. No, I'm just kidding. Okay. We started off not controversial, we got a little controversial, and here's the one that always makes me squirm. Oh, I do want to add an anecdote. So I taught just over dinner a couple years ago, I like talking about this stuff, and I was telling my kids about the Barnett case and explained to them why I thought it was important, and I didn't really think anybody at dinner cared, and I didn't think the kids really, they were kind of like, okay, thanks Dad for that illuminating discussion. And then about a year later, I found out that my daughter had opted out of the Pledge of Allegiance and never told me about it. And then she had just said it, and she's like, I just wanted to see what the school would do, and they let me opt out of it. And then she's like, but I started doing it again. And so I just thought it was so fascinating, and I couldn't believe that I was actually just hanging out with her, and then when she told me that, I like almost fell out of my chair that she did that. But now she remembers the Barnett case, that's for sure. And I'm sure the teachers now remember the Barnett case. All right, now the case that makes me squirm, and one that I've talked about with my kids a lot, and I think it's really important to think about is free speech worth it when we're talking about this next case? So this is the National Socialist Party of America versus the Village of Skokie, Illinois. And the Village of Skokie had about 70,000 people, which I think is maybe a little bit smaller than Lawrence, Kansas. About 40,000 of the residents were Jewish, and thousands of those residents had survived the Holocaust, had survived concentration camps. And what the Nazi Party wanted to do was parade or essentially march through the town of Skokie. And so they had announced their intention to do this, and there were a lot of concerns, obvious concerns about what would happen if the Nazis were actually allowed to parade through this predominantly Jewish town. And so the town of Skokie passed several ordinances. You had to get a permit to conduct these marches, but in connection with the permit, you had to post a $300,000 bond. You had to have a $50,000 property damage insurance policy, and there was a prohibition on materials that would promote hatred toward persons. And so then there's a very strange procedural history to this case. This is a United States Supreme Court decision that's referenced here, and then there are companion cases afterwards. So if you ever want to look this up, you got to do a little bit of digging. But what Skokie did was they defended their permitting regime because it lacked social content. There were they alleged that there were going to be false statements of fact, and that the parade had no marching. I call it a parade because it's easier to remember that way. And it had no constitutional value. So there was no merit to what the Nazis were doing. And I think, not legally, but practically, I think maybe a lot of people would agree that there wouldn't be any merit to that. And in the companion case, there were, at the circuit court level, I thought they really hammered home what they viewed as what the First Amendment meant. But it still does raise the question, by the way, can the Nazis parade in Skokie? What does everyone guess what you think the court ruled? Can they do it? Thumbs up. Can they not do it? Thumbs down. Thumbs up. We got one. We got a lot of thumbs ups. Okay.
They have to, I think.
Okay. So.
It's terrible. I know.
Yeah. So I was struck by the verbiage in the opinion because it was clear to me that the court was struggling so much with this decision. And here's what they said. If any philosophy should be regarded as completely unacceptable to a civilized society, it's that of the plaintiff, who, while disavowing on the witness stand any advocacy of genocide, have nevertheless deliberately identified themselves with a regime whose record of brutality and barbarism is unmatched in modern history. And that would be a good place to start. But under the First Amendment, there is no such thing as a false idea. However pernicious an opinion may seem, we depend for its correction not on the conscience of judges and juries, but on the competition of other ideas. So I'm going to stop real fast. The competition of other ideas. We've talked about that. The response to speech that you don't like, according to Madison, is other speech. It's not to censor. And then they quoted Justice Jackson. In the words of Justice Jackson, every person must be his own watchman for truth, because the forefathers did not trust any government to separate the true from the false for us. And the result we have reached is dictated by the fundamental proposition that if these civil rights are to remain vital for all, they must protect not only those society deems acceptable, but also those whose ideas are quite justifiably they reject and despise. Yes?
So I think the actual crux of this is, does free speech cover threats?
So, that is a great segue into other cases. But here's my question to you. And it really does, I think, go to the generational divide statistics that we see before. So, is someone you disagree with, does that constitute a threat?
That is different than Nazism directly threatens human people with violence.
So in your view, if you want, you don't have to, but in your, and this is the thing that I talk about with a lot of people, like, was there a likelihood that that would provoke some sort of violence against the Nazis? That's one of the things Skokie was arguing. I'm paraphrasing it maybe a little too much. But by you bringing up threats, do you think that this is a threat?
I think it is an ideology of brutalism and threats. It is promoting violence against people, and I don't know any other way to voice that demonstration of ideology than a threat to those people.
So, as I understand what you're saying, then you perhaps would have felt comfortable saying that the Nazis should not have been allowed to parade. Okay. I think that is a very fair, practical, personal viewpoint. I can understand that viewpoint. What I am persuaded by, because I have a perspective, is that that is not the threat or the type of threat that the First Amendment would prohibit. And because if we then go down the path of that's a threat, then what speech do you disagree with wouldn't be considered a threat? And that's where I have a pretty strong viewpoint that I think, like, I can't imagine how horrible it would have been for the survivors of concentration camps to see Nazis walking down the street. I can't actually put myself in that position. So Renee says it's a threat. I disagree with that. And the reason I disagree with it is because, and maybe I'm taking a more lawyerly view, but my view is a threat is something very specific. And there are First Amendment cases that talk about threats. And so what the Supreme Court has done is gone through and said, yes, we cannot prohibit speech because it might cause violence. Because if we do that, then it's essentially going to be a problem, because then where do you draw the line?
Would the fighting words doctrine apply here?
So the fighting words doctrine does not apply in Skokie. There is a fighting words doctrine, and that has changed over the years. And so now there's a very specific kind of test over fighting words. And this really, and so if memory serves, Skokie was not relying on the fighting words doctrine. That they actually said, yeah, maybe there are going to be issues, but that's not why we're doing this.
Explain what that is.
Yeah, so, sure. So the fighting words doctrine is a very specific kind of test, and as this lecture was billed, what speech is protected, what speech is not protected. And so I want to get to a couple of things if I can then. Well, so fighting words has to be a very narrow set of circumstances, and it's almost like a face-to-face threat to a person of essentially imminent violence. And so what the court has done is really narrowed the scope of fighting words, so it's just that limited instance. It doesn't take into account things like Nazi parades, because otherwise then it could be used to limit any speech you disagree with. And it can be a fine line to draw. And so in 1969, Brandenburg v. Ohio, that was a KKK speech at a rally, and the First Amendment cannot forbid advocacy of the use of force or a law violation unless it's directed to inciting or producing imminent lawlessness and likely to incite. And so there are things like that. And we're going to get into a little bit more in the next case. So really the question is, and I think maybe we would have some disagreements, is whether free speech is worth it if we're allowing Nazis to parade. And that's a question that you all have to answer on your own. Okay, Texas v. Johnson. All right, just tell me what you think the outcome is, unless you've heard of this case, all right? Can you burn the American flag?
Yes, you can.
Okay. Gabriel's struggling. Gabriel, can you burn the American flag?
No.
Oh, first, can you? Yes, legally. Can you burn the American flag?
No.
Yes.
Okay. So I think everybody, Renee.
No.
Okay, Renee says no. Go ahead.
In the code, in the flag code, because I belong to Daughters of
Yep,
American
okay.
Revolution, and in the flag code book, it says it is illegal to burn the American flag.
Okay.
But no one pays attention to that anymore.
Okay. So that raises a very interesting question, which is, if there's a statute that says you can't burn the flag, does the Constitution override that and say, yes, you can? All right, now I can't see your name tag.
It's okay, Victoria.
Victoria.
I think it's honestly kind of disgusting, but yes, I would say it's protected under free speech.
Okay. It is protected, okay? And this was a 5-4 decision by Justice Brennan, and it's a really interesting opinion. I would commend you to read it. What happened was Greg Johnson burned an American flag in front of the Dallas City Hall. He was protesting the Reagan administration. If memory serves, there were a lot of people who were demonstrating. He was the only one who was prosecuted, and there's evidence in the record that says several offenders were seriously offended by the flag burning. And he was convicted of flag desecration, and then it goes up to the United States Supreme Court. And as I was talking about this with other people, it is, I couldn't imagine standing in the shoes of a veteran who maybe had fought in the Vietnam War and seen their friends or people in the Army with them who had lost their lives fighting for this country and had people they loved and cared about died for their country. And then here you have Greg Johnson burning the American flag. And I don't think I've made this up, I think what happened also is when the flag was burned or almost done, I think somebody picked it up to then try to properly, you can bury a flag. And so I think somebody had done that later. But
Actually, you can, when you retire the flag.
you can burn
You
it.
have a ceremony.
Yes.
Where you do burn parts of the flag.
Yep.
That is according to,
That's right.
law or whatever, but yeah.
And that was-
Retire it.
That's right. You can burn it or bury it. That's part of.
When it's damaged.
Yep,
yes.
that's right. And that actually was discussed in the case. And so here's what the majority opinion said. We are tempted to say, in fact, that the flag's deservedly cherished place in our community will be strengthened, not weakened, by our holding today. The holding was you can be allowed to burn it. Our decision is a reaffirmation of the principles of freedom and inclusiveness that the flag best reflects, and of the conviction that our toleration of criticism, such as Johnson's, is a sign and source of our strength. Indeed, one of the proudest images of our flag, the one immortalized in our own national anthem, is of the bombardment it survived at Fort McHenry. It is a nation's resilience, not its rigidity, that Texas sees reflected in the flag. And it is that resilience that we reassert today. And the way to preserve the flag's special role is not to punish those who feel differently about these matters. It is to persuade them that they are wrong. So again, the response to the speech you don't like is to persuade them that they're wrong, that should be more speech, not less speech. And another anecdote, I, at one point in my life, thought that anybody who burned the flag should go to jail. And I was in Boy Scouts, and I expressed this in an offhanded way to one of the dads in my Boy Scout troop. And I was like, oh, what do you think? And he's like, the reason I fought for this country is so people could burn the American flag. And my head like exploded. I could not believe that's what he said. And so I went back and I kept asking him about it. And he said, that's the whole point of the flag. The whole point of the flag is that you have freedom of speech. It's a symbol of speech. So how can you prohibit the flag burning? And that was actually a pivotal moment in my life. He was a lawyer. I ended up working for him when I got older.
He was recruiting.
Yeah, he was. He didn't even know. And one other point. We can imagine no more appropriate response to burning a flag than waving one's own, and no better way to counter a flag burner's message than by saluting the flag, and no surer means of preserving the dignity even of the flag that burned than by, oh, here we go, as one witness here did, according its remains a respectful burial. We do not consecrate the flag by punishing its desecration, for in doing so we dilute the freedom that this cherished emblem represents. So, pretty amazing verbiage. And that case was 1989, so fairly relevant, modern times. And so here we talked about First Amendment cases and what the United States Supreme Court has talked about. We've talked a little bit about what's not protected. Incitement, very narrow category of speech. Things like libel and fraud and perjury. And then obscenity. The obscenity doctrine is very difficult, I think, for anybody to understand. And so we're not going to get into obscenity, not because it's not interesting, but because we could probably spend 3 or 4 days just talking about obscenity and what it means and how do you decide it and all that kind of stuff. All right. Sometimes free speech is very theoretical. And the question about is free speech essential, sometimes we just think, well, that's some other case to some other person and it doesn't really matter. And it really doesn't hit home. So here is a real life example of a couple who thought free speech was essential. To them, free speech was incredibly important. And I represented the Bunners in this case back in 2019. So I'm going to try to show the video. Let's hope it works. If not, we're still going to talk about it.
Come here, girls. Come here, girls. Treasure.
In Kansas, farmers are allowed to sell raw milk, which is milk that has not been pasteurized. Even though raw milk is a perfectly legal product, farmers like Coraline and Mark Bunner are banned from advertising their raw milk away from their farm.
Because we put so much into our dairy and into our goats and the product that they produce, it's really frustrating, and I don't even know the word to use, but that we can't talk about it, that we can't tell people what we have out here.
These goats out here, we spend a lot of time, a lot of money, a lot of effort in feeding them, taking care of them, milking twice a day. So a lot of our life is spent raising these animals, and we love them. They all have names. We go to different places and we talk to people about our goats and how wonderful our goats are. Then the question will always come up, what do you do with the milk? We can't tell them that we'd like to sell it.
We live in America. But because we can't talk about it, is an infringement upon my free speech rights. Our girls work hard, and we think we should be able to share what we get from them.
But I think about other people that are going to be starting up in this business in the future, other people that are currently doing this. They're being censored, they're being restricted, they're not allowed to talk about this, and to see people's rights taken away from them, that's the big reason I'd like to see this change, because people's rights are being infringed on, and this does need to change.
All right, so Mark and Coraline, as you saw, were raw milk producers. All they wanted to do was build a website to tell people about selling raw milk, and they couldn't do it in Kansas. For about 50 years, there was a statute on the books that said the only thing you could do was put up a sign on your own property that said raw milk here. That was it. Mark and Coraline lived out near Hayes on a dead-end road in the middle of nowhere, and nobody was driving past their property. And as you could see, their livelihood was wrapped up in producing raw milk. And they loved raw milk. They loved the benefits of it, but the state of Kansas would not let them talk about it. So in 2019, Kansas Justice Institute filed a lawsuit on behalf of Mark and Coraline saying that violates the First Amendment and the Kansas equivalent to the First Amendment. And to his great credit, the Attorney General at the time, Derek Schmidt, agreed with us, and we signed a consent judgment. And so now Mark and Coraline have been able to talk about raw milk. They built their website. It's really cool. It's Shepherd's Gate Dairy out near Hayes and Pfeiffer, Kansas. And so for them, I think it comes back full circle. Is free speech essential? Well, it certainly is for Mark and Coraline. And these are real life issues happening today. It's not just theoretical. Yes, Renee?
Just wanted to say, I drank raw milk. And a neighbor, I was going by, and I don't know what I was doing that day, but anyway, I went to his house. I think I was campaigning. And I went to his house, and he had raw milk. And he said it's really good for allergies. And my daughter has allergies. And so I just took a sample of it, and it's really good if it's ice cold. It's not good if it isn't. I just want to say that. But he gave it to me. He did not sell it. He said, I can't sell it. He said, but I'll just give you a gallon. So he gave me a gallon. And but anyway, I just wanted to tell you that.
Yeah.
It just brought back memories.
Yeah. So what I thought was so horrible about this statute was, as I was driving around the state talking to people about it, they were being treated like drug dealers. And what I mean is, if they were out in the town square and somebody said, do you sell raw milk? They couldn't answer. So they would say things like, well, you know, when I was a kid, we drank raw milk on the farm, and raw milk's pretty good. Do you want to come back to the house? Because they were afraid they were going to get in trouble from inspectors. So they would come up with allegories, or, hey, and they would never say, we can't tell you, because they were also afraid that would get you in trouble. And so it just, imagine your livelihood. You can't even talk about the thing you're passionate about.
We do have 30 minutes left.
Okay, we're almost done. Yeah.
So sorry, I do have a question.
Yeah.
I just this sounds so bizarre. Like what possible reason could they have for not allowing them to talk about
Okay,
this?
it's a very paternalistic reason. The reason for it was the department. I'll give you what I think is going on, and then what other things are happening. There is a fear, and I'm not going to get into whether it's a good fear or not fear. There is a fear that raw milk is dangerous. So what they did not want was to advertise raw milk, because then they thought more people would drink it. And if more people would drink it, then there is a chance that more people will get sick. And if more people got sick, they might die. And so therefore, the theory was, if you advertise it, people are going to die. And to me, that is a very paternalistic reason. Because again, we've talked about the answer to speech that you don't like is more speech, right? And so here, I think the government was saying, we don't want people to know about raw milk. But what I think is so crazy is if you have a problem with raw milk, then talk about it. Say that we think raw milk is dangerous. And for these dairies, they can actually say, look at my dairy, look at how clean this is. But they weren't allowed to do any of that. So then you had like this really almost this underground kind of economy that was happening. And how does that make people safer? That's my perspective. Now, we were very pleased and somewhat surprised that the government capitulated so quickly. I think they realized they were probably going to lose. That calls into question also this thing called the commercial speech doctrine, which we don't have a lot of time to talk about. But there are some cases that say we give commercial speech less protection than political speech or things like parades. Okay, now, oops, here we go. Flying saucer hamburgers. Okay. This is a case I'm currently litigating, so I can't get into a ton of details, but the city of Salina, Kansas has murals virtually everywhere in downtown. A mural, from my perspective, is just painting on a wall. So the city of Salina encourages some types of murals, but prohibits other types of murals. And how they have done it is through their sign code. So they will say, if a mural pertains to a business, it's considered a regulated sign, meaning it has to meet size and permitting restrictions. But if a mural does not pertain to a business, it's an unregulated mural. So they have created this mural sign distinction. And from my perspective and the district court's perspective, that was a violation of the First Amendment. And so Steve Howard owns the Cozy Inn, which is this really cool hamburger restaurant in Salina. It's been around for more than 100 years. They cook sliders. It's like White Castle. The Cozy Inn is indeed cozy. There are only 6 stools inside of it, okay? Murals, again, are everywhere in Salina. Steve, according to depositions, I'm not making this up, wanted to get in on the mural scene, so he commissioned somebody to start painting this. This is not the ultimate result, okay? Because the city of Salina told him to stop. Our theory of the case was that this is a content-based restriction on speech. We haven't talked about that yet. But if the government is going to pick and choose which speech is allowed and which speech is prohibited based upon the content, then the highest level of scrutiny should apply in the case. It's called strict scrutiny, okay? That was our theory of the case. Our alternative theory was, even if this was not a content-based restriction of speech, it is still unconstitutional because there is no legitimate reason why the government can prohibit this type of mural. The government's theory was we are allowed to regulate signs and we are allowed to regulate speech because of safety concerns or aesthetic concerns. One of their theories was that signs implicate property values. Our response to that was, you cannot prove, there is no evidence that this mural implicates property values differently than a mural that does not pertain to a business. And you cannot prove that this mural implicates traffic and safety concerns in a way that is different from another mural. And so they even have, the city has a mural on an abandoned grain silo, which is over 100 feet tall, and virtually in the middle of downtown. And the government's position was that mural does not implicate traffic and safety, even though it's over 100 feet tall, because it doesn't pertain to the business, but this one does. The city of Salina lost at the district court level, so Judge Toby Krause ruled in our favor, and the city of Salina has appealed the case. It is now pending in front of the 10th Circuit Court of Appeals, which sits in Denver, and there is a perhaps a circuit split going on, meaning there are some circuits who say one thing, so our case is very important. But what is more important, and the point of me talking about this, is for Steve Howard and the Cozy Inn, free speech is absolutely essential. This is his personality on the wall. He's got burgers-esque UFOs shooting the wall with ketchup and mustard. It's whimsical, it's strange, it's cool, it's weird. That's his personality. And so why can the government tell him he can't do this? Our position is the government can't do that. So hopefully we've traced the thread all the way from Cato's letters to Salina, Kansas, and hopefully I've been able to explain why I think free speech is important. But we'll do one last slide here.
There's some outstanding reporting on that in the Sentinel also.
There is a lot of media coverage on that case. I would encourage you to read it. Okay. Ronnie Reagan. I love this quote. I believe in this quote. I think it's really important. I'd like to leave you with this before we get into other Q&A. Freedom is a fragile thing, and it's never more than one generation away from extinction. It is not ours by way of inheritance. It must be fought for and defended constantly by each generation, for it comes only once to a people. And those in world history have known freedom and then lost it, have never known it again. That is why I was so concerned with the stats that we started off with. Because if it's true that that is how a younger generation thinks, then my parents haven't done a good job, and I haven't done a good job, and the Supreme Court hasn't done a good job, and media hasn't done a good job of explaining persuasively why speech is important. All right, Q&A time. I'm ready.
I'll lead off one. You kind of hinted at this a little bit, but when we talk about free speech, you can say whatever you want to say, blah, 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 but it's really, we touched on kind of the part of free speech is you're free to be silent as well, right? Yeah. In a sense, with in the classroom with the Pledge of Allegiance. And so with the Board of Education stuff, the compulsory that the students have to be there, and it's public, and it's by law, and so then free speech is kind of carried out with the right to be. Now, I had raised my hand about should a school, I was kind of thinking of a private school of some sort, could have the right to require free speech, and if you don't pledge allegiance, then you can, be dismissed from class or whatever, dismissed from the school. But that's in a private case. So I feel differently if a public school, then you've got the right to be silent, I would think. So I didn't know if you had any comments on silence.
Yeah, so I think that when people want to do research about this, one thing to look at is called the compelled speech doctrine. And so that really, there are a lot of cases that talk about the government cannot compel people to speak. You can't force somebody to ascribe to things that you don't believe in. And that's coming into play in courts now when it comes to, I'll just describe it as DEI trainings for government employees, so for teachers. So there are cases percolating about can a school or another government entity require people to agree with certain statements in DEI trainings. And it is gonna be an issue that's coming, it's already up, but it's gonna be percolating even more. And I think it's really, the compelled speech doctrine is going to come into play here, because there are some, as I understand it, there are some requirements that you can't, so you're required to do a training and you can't finish the training unless you agree with certain principles in that training. And there is a difference between private companies doing it and governmental entities. And so this issue is going to pop up, and I think it's very important, and I think people need to start thinking about it. And when it comes to free speech, it is not whether DEI is important or whether the principles like you can learn from it. It is whether you can be forced to agree with something if you don't agree. And to me, then the whole Barnett case really helps inform my views on it. Renee.
Okay, I have an experience. I do teach the Constitution in 5th graders in several counties. And it's basics, just basics. First Amendment, I really go in on the First Amendment. But one school denied me the right to say our current president's name. And they were the only school that did not want me to come back. And one of the teachers, I guess, told the principal, well, she said Trump. And I don't name names. I usually talk just mainly about our founders and my patriots in the Revolutionary War. But I mean, the principal, I called the principal, I kept calling her. Finally, she got back with me and she said, Renee, she said, one of the teachers said, you said Trump, the word Trump. And I'm thinking, oh my gosh, is it that bad? And I said, but I didn't say it. That's the thing. I know what they want and what they don't want. I know they don't want politics involved in teaching the Constitution and Bill of Rights to our little fifth graders. But actually, many of the fifth graders come up to me afterwards and say, oh, President Trump, they really like him. I mean, it's like, wow. And I can't say too much because, the teacher's standing there. But that was the only school. And it's pretty conservative where I live, out in where I live in the area, so I'm pretty, they at least allow me to come in. I'm volunteer, completely volunteer, and they let me come in and up to an hour and talk. But I just thought that was horrible, that you can't even say a president's name,
Here's my response to that. Even though you're not asking for a response, I have the speaker privilege to give my response. So my response to that is a couple of different things. Is that a written policy? Is it an unwritten policy? And would the school have allowed a speaker to talk about President Biden or President Reagan or President Clinton? And can we only talk about historical presidents? Is it because is it a viewpoint issue? They don't like what they believe Trump stands for, so they're going to prohibit you from talking about it? And it's also complicated because the courts have gotten into speech at schools is a little bit different than speech out in the public square. So that's a very interesting, fascinating issue.
Yes.
I had been hearing about that. I did not know it was happening in Kansas.
Yeah, it is actually happening, and it's not in all schools.
Yeah.
It only happened, and I've been doing this for 13 years, so it only happened one time in that school. And I told her I did not say his name. I'll say presidents, but I don't say a name because I know I'm not allowed to. They told me, they're very political, or non-political, I guess I should say. And it's really hard for me because I am a little political, but I know I'm not supposed to. So I told her, no, I did not. I don't know where she got that from. And I said, but I tell you, I won't mention Trump's name, because I didn't want the students to not have me come in, and that's probably the only time they hear about our Constitution, to tell you the truth. And so, I just agreed with her. No, I will never do that. Although I don't remember doing it, but I will never do it going forward. So, that was resolved, and I'm back in the school. But I just,
That's interesting.
It's sad.
That is interesting.
Sad.
We had a school, I'm looking it up now, I can't remember the school, but it was a 6th grade class, and the children were instructed to write the name of their heroes on the board. And someone wrote Charlie Kirk. And the teacher informed the kid that he wasn't a hero, he was a whatever. The next kid comes up and he puts Donald Trump's name on the board. She said, that's not allowed either. So we couldn't determine if it was a school policy or just this political bent of this teacher. But that's the extent of this insanity that this freedom of these limitations on freedom of speech even extend into our elementary school. It's just ridiculous.
So the way that I have grown to think about these kinds of issues is, do we want rules that would be lopsided? Do we want the same rules? So the way that I think about it is, would I want kids to be able to say that a different president is their hero? And my viewpoint is, yes, you get to say whoever your hero is. It shouldn't be one person is yes, one person is no. We're only going to say a certain, that that is so frustrating to me, especially when I do things like this, when we're talking about the whole point of free speech. It's so you can voice his opinions. And kind of leading into that, we had been alerted to a school down in Winfield where students were protesting Turning Point USA club from going into the school, and it seemed as though that perhaps the school was going to follow the wishes of some of the school population and prevent Turning Point USA affiliate to go in. And we sent a demand letter, what amounted to a demand letter, to the school saying you cannot prohibit this school. You cannot prohibit the Turning Point USA chapter. We had a copy of their policy. The policy allowed them to do Fellowship of Christian Athletes. The policy allowed them to do Young Democrats, Young Republicans. And so why would you prohibit this club? And it turned out that then the club was allowed to move forward. Whether it was a result of our letter or not, I would like to think it is, but there's no way for us to know because they just did it, so we never ended up suing over it. But my viewpoint is, yes, you get to have Young Democrats. Yes, you get to have Young Republicans. And if there was a club that was the opposite of Turning Point USA, like if they wanted to do a socialist club or something else, like they should be allowed to do it as long as it's...
I'm a little on the fence about young Nazis, but...
Yeah, so that would be...
I guess, since we're talking about free speech...
That always gets really weird. Those are the really hard cases.
Yeah.
It's bad. I think it's, and I live in a pretty conservative area. It's really bad in these schools. And I have, with my DAR sisters, I have a little video that I show. They can't even bring it into the school. The school will not allow them to come in and teach the Constitution and even show the video, which is non-political. It's nonpartisan, non-political. And that's what our organization is. It's nonpartisan, non-political. So we can't really push politics in our meetings or anything. And when we go out and teach, we can't. But we're very patriotic. So it's a hard place.
I was wondering if you have hope for us on how this generation that's now willing to shut people down, possibly even supporting violence to shut speech down. I just see it as another, we blame our phones a lot for siloing people, but that generation doing that makes me think that makes you siloed as well. If you can't hear the exact thing we're talking about, the speech that you disagree with, then it just continues to keep you in your echo chamber if you're allowed to shut down speech. And so maybe there's more than just the phone is our problem. Maybe, and I don't know what the answer would be, but since you think about this stuff a lot, where do you think we could go?
I think my current thought on this is lectures like this that have to happen. And there's Judge Willett, who sits on the Fifth Circuit. He was Justice Willett on the Texas Supreme Court. He is now going out and doing civics lectures. And I think that is, those things have to happen. That people have to have this conversation. And we have to talk about founding era things. We have to explain the whole point of the First Amendment, the purpose of it. And I think we have to be willing to speak up. And the reason I say that is when I was in college at the University of Kansas, I would feel that if you expressed a certain viewpoint, there'd be some teachers who wouldn't agree with it, and it might impact your grade or something like that. But it was nothing like what I'm seeing today. And I can't tell if it's because I'm just older. I'm like, oh, that generation. I am aware that I'm older now and I'm removed from it some. But I think we have to encourage younger generations to actually talk about these things and not self-censor. But I don't know how you teach that. That's a very hard thing to do. And so just encouraging and then standing. So I am the ACLU has done fantastic work on free speech, and KGI has done fantastic work on free speech, and I think that both are really important organizations. And I think we try to work with the ACLU. I think the ACLU tries to work with us on free speech issues. It should be an area where we overlap, and those are very important things. And I think we just have to support that. We have to support organizations like FIRE, which is a free speech and expression organization. We just have to encourage these things and talk about it.
I want to add to that. I think it starts really young in curriculum, and parents need to pay more attention to really what's being taught inside their kids' schools and stuff like that. And if there are parents that are not engaged, and there are teachers in these schools who still believe in these things, maybe they can find a way to reach out outwardly outside of the school system to begin to maybe formulate outside of schools groups where the kids come on clubs, where the kids can have civic classes and stuff like that, where they can be taught, but find ways even outside of the school system to begin to draw the little ones in. Because it really starts young with planting up their hearts pride for country and love of community and faith and stuff like that. So I think we're looking at them at this age, and a lot of times you've lost them really. By that time, you really have lost them.
We do have a Children's of American Revolution, and this is the 250th year anniversary of our country. So I'm planning a lot of events in the area. So, but that's an organization that really needs to get out there more. I don't think, they're young though, but they're learning a lot, and I think they would, as far as youth, I think they would help. And I am having them come in and speak to some homeschoolers in Lacine. And anyway, but that'd be good. I wanted you to say something about Justice Thomas, his speech. That was just wonderful.
So I haven't seen it. I have heard about it. I've read about it.
Yeah. I saw parts of it, but it was like 2 hours.
Yeah.
I mean, it was a long speech.
Yeah.
But it was very good. And then I would like you to talk about the Lacine lawsuit. Are you going to get into that?
Well, I can.
The COVID?
So it's not free speech related, but we did represent 2 people down in Lynn County during COVID, where the local health officer had imposed a requirement that you maintained a list of people who came into your business, what time they got there, who was in their party, for example, like at a restaurant, and then what time they left. And it captured almost every business in the county, and then those documents were required to be made available to the local health officer upon request. And if you didn't turn over those documents, the health officer said he could impose an automatic fine. And our viewpoint on that was that violates the Fourth Amendment. And so, because think about our theory of the case was, because every business essentially in the county was required to do this, you could see if a person went to their lawyer, their doctor, a restaurant, and then you could track everywhere they have been within a certain period of time, and there was no judicial oversight. And so part of the warrant clause, part of the Fourth Amendment is you have to get a warrant and the judge has to sign off on it. But here the local health officer was saying, nope, it's COVID, I can get these. And the justification or purported justification was, we need to be able to conduct contact tracing. So if somebody got COVID and got sick, we would need to know exactly where everybody was at all times. So we filed a federal lawsuit. We had oral arguments on the case, and then based upon the questioning, it became clear to me that we were going to prevail, and then 2 days later, the local health officer changed the requirement to not force that on people.
That's good.